첫 번째 기조강연입니다. 자연의 권리라고 하면 여러분들은 어떤 나라가 가장 먼저 떠오르시나요? 미국이나 뉴질랜드도 있으실 텐데요. 저는 가장 먼저 떠오른 나라는 에콰도르입니다. 세계 최초로 헌법에 자연의 권리를 명시한 국가죠. 바로 그 에콰도르 헌법제정회의에 자문으로 참여했던 미국의 환경법 전문 변호사 토마스 린제이 님이 이번 그린컨퍼런스에서 기조강연으로 이야기를 나눠주셨습니다. 민주적 환경적 권리센터 CDER 수석 법률 고문으로 활동하는 토마스 린제이 님은 에콰도르 헌법 외에도 2006년 펜실베니아주 타마과 자치구에서 있었던 세계 최초 자연권법 초안을 작성했습니다. 현재 전 세계로 확산된 자연의 권리 운동과 지역사회 권리 운동을 이끌고 미국과 세계 여러 지역에서 수백 건의 관련 법률을 제정했죠. 이번 강연은 시차로 인해 녹화로 진행되었습니다. 그럼 기조강연으로 자연의 권리란 무엇이며 각국의 생태법인 사례에 대해 들려주실 토마스 린제이 변호사님을 화면으로 만나보겠습니다.
So it's good to be with everybody today, even if it's virtually. But I've been asked to talk about the general movement towards recognizing the rights of nature around the globe. And so we're going to talk about that movement. And the first question that people generally ask when we talk about the rights of nature is, what is it? What do we mean when we say rights of nature? And essentially, it's the recognition by written law, so a law passed by a governmental entity or by a judge or a court, of the legally enforceable rights of nature as a whole, or of species and ecosystems. So generally, when we talk to folks about this concept, we're talking about taking human rights and how human rights have been treated under constitutions and various legal mechanisms, like in South Korea, Chapter 2 of the South Korean Constitution, dealing with the right of personal liberty, freedom of residence, freedom of occupation, freedom of speech. Those types of human rights, which are the highest way, the highest form of legal protection under the law to recognize those rights, taking that concept of human rights and transferring it to nature, so that nature is protected with the same kind of rights framework. So we think human rights under the law, and then elevating the protection of nature to that highest form of legal protection, which is rights. So once again, either by written law or by jurisprudence, court-made law, of the legal rights of nature. So this isn't about resolutions or declarations. It's about binding legal rights for nature. People also ask sometimes, what are some of those rights that have been recognized in these rights of nature laws? So these are actual rights that have been recognized by laws around the globe: right to exist, thrive, evolve, right to restoration, a right to habitat, right to flow for certain rivers or waterways. These are the types of rights we're talking about. And again, legally enforceable rights, not just declarations, but actually rights that are enforceable under the law and in courts. So another question we get asked is, why do we need rights of nature? Well, primarily it's because most of our environmental law frameworks treat nature as a commodity or as property, basically as a thing that lacks even a basic right to exist. And whereas we think about environmental laws as being protective under our current system of law, environmental laws actually legalize certain harms. So, for example, if you wanted to dump waste into a river that would currently be legal, that governments often issue permits that make it legal. So that environmental laws kind of legalize certain environmental harms, like fracking or drilling, extraction, filling of wetlands, climate change, those types of things that, even though we think about environmental laws as protective, generally they're actually about legalizing certain environmental harms. And I think the question we get less now is, why rights of nature? Why treating nature as a thing or as property is a problem? We see the problem all around us, whether it's ecosystem collapse, species extinction, or climate change. We're kind of on this path to environmental destruction and degradation on a scale that we haven't really seen yet, and that we can barely imagine. When we talk about rights of nature, we usually trace the origins of the rights of nature back to First Nations or indigenous communities. In the US and also around the globe, First Nations treat nature as something that can't be owned. They tend to speak about nature as a living being or as a relative, but they treat nature differently from a cosmology standpoint than Western systems of law do in terms of treating nature not as property, but as something different. And that difference can be seen when we look at a comparison between Western systems of law or civil systems of law in some ways and indigenous or First Nations systems, cultural systems, as well as legal systems. On the indigenous side, nature is treated as a living being. The Anishinaabe people in the U.S. and the state of Minnesota talk about the flying people and the singing people being the birds and the fish. The swimming people being the fish, flying people being the birds. The Yurok Nation, a tribal nation in California, state of California, treats the Klamath River as a relative or as a living being. And contrast that to a Western system of law, which treats nature essentially as a dead thing or as a resource. It's why we talk in terms of natural resources rather than using other words to describe the natural environment. And of course, philosopher Sir Francis Bacon, big Western philosopher, used to talk about torturing nature on a rack to extract her secrets. I don't know about you, but I can't hold those two things in one hand, talking about the flying people, the swimming people, and the singing people, yet talking about torturing nature on a medieval torture instrument to extract her secrets. So two completely different systems, completely different cultural systems, which are reflected in the legal systems of those cultures. Some key elements of rights of nature laws that have been passed around the globe. So again, this is legislation, rights of nature laws that have been passed. The first element in most of these laws has been a recognition of rights, which makes sense. You're declaring or creating certain rights for nature. So nature is recognized as a living entity with certain binding legal rights. The second piece is enforcement. So the rights themselves would be no good without enforcement. You have to find a way to provide a way to actually enforce the rights. In most of the communities that we've worked in the U.S. and around the world, any member of a community, any resident of a community that's passed a rights of nature law has the legal authority to represent the ecosystem in the system of law to bring a lawsuit to enforce those particular rights. And we're going to see that in a couple minutes, where in the U.S. and in other places, we don't have people as plaintiffs. You actually have ecosystems as plaintiffs in cases, as litigants in cases in courts over rights of nature. And then the third element is remedy. There has to be something that you win when you're done with these cases. And most of the wins, the remedies in these laws come down to restoration of the damaged ecosystem back to its pre-damaged state. So recognition of rights, enforcement, and remedy. And then in addition to that, governments that pass rights of nature laws actually need to change their existing codes, their existing laws to comply or conform with the rights of nature law that's passed. After all, you can't allow development in a floodplain if you have a rights of nature law that have been passed to protect that floodplain in the first place. So you need to change your existing laws to recognize the passage of that rights of nature law. Most people, when they hear about rights of nature, hear about Ecuador first. It's the first national constitution to enshrine the rights of nature, which happened in 2008. And I know Natty Green will be talking more about Ecuador, so we're going to go pretty quickly through this. But these are the articles in the Ecuadorian constitution that we helped to write. Articles 71, 72, and 73 basically holds that nature has a right to exist, maintain, regenerate its life cycle, structure, functions, and evolutionary processes. Nature has a right to restoration, and that the state has a responsibility to apply certain measures to protect those rights. Again, the Ecuadorian Constitution, this is the actual text that passed in 2008. We use this slide to talk about, what happened next after the Ecuadorian constitutional provisions were passed. There have been a bunch of cases heard by the Constitutional Court, which is the highest court in Ecuador to hear constitutional issues, which rights of nature became. But you'll see in these cases, the Vilcabamba River case, case where the river was a plaintiff to protect its flow against having waste dumped into the river. The shrimp case in 2015 dealt with a shrimp farm in a fragile mangrove ecosystem. Perhaps the case that's become the most famous is the Los Cedros case, which is a cloud forest in Ecuador, where rights of nature were used to overturn mining permits, with the court holding that the rights of the cloud forest would be violated if the mining permits were not overturned. A couple other cases as well, but all to say that the Ecuadorian constitutional provisions have been enforced, and that certain things have been recognized. Nature is a subject of rights. People have standing to invoke those rights. They've also been invoked in other cases dealing with shark finning and a variety of other criminal and civil cases as well. So a lot of enforcement following that Ecuadorian constitutional provisions being inserted into the Ecuadorian constitution as the first national constitution. Panama passed a rights of sea turtles law back in 2023. We talk about this just as an example of rights of nature laws being applied to a specific species. So protecting turtle rights as a piece of written legislation at the national level in Panama. These are the places that have passed rights of nature laws over the past 20 years. National level, we're talking Ecuador, Bolivia, Uganda, New Zealand, Panama, and Spain. State and local laws have been passed in places like Brazil, Mexico, Canada, and of course in the United States. And then local policies have been passed by governments in Northern Ireland. Linda Sullivan will talk more about that in a couple minutes. England, Ireland, and Australia. So what started in a very small community, the first rights of nature law was passed in a very small community of 10,000 people just northwest of Philadelphia, the United States, has spread to these other places and been adopted by these other places as well. Some key court decisions, Colombia, India, Bangladesh, and Peru, judges have jumped in. Even though there aren't written laws that have been passed in these places, courts have begun to recognize things like glaciers and rivers and other ecosystems as having certain rights. So not just written law, but actually court-made law or judges moving forward with these decisions as well. In the U.S., indigenous communities, First Nations, have been at the forefront of passing rights of nature laws. This is a list of the different tribes in the U.S. that have passed rights of nature laws, including at the very end. The most recent was the tribe called the Rappahannock tribe in the state of Virginia. They became the first to put rights of nature into their tribal constitution. So not just a regular law, but actually a constitution of the tribe. And that happened in 2024 to protect the Rappahannock River, which is very important culturally to the Rappahannock tribe. So people ask about enforcement in the U.S. There have been 3 enforcement cases that have been filed in the U.S. Again, much more enforcement in other countries than the U.S. But these are the 3 cases. We talk about these 3 cases because to show how different they are from conventional litigation. In each of these cases, you have the ecosystem itself or the species itself as a plaintiff. So in the first one, you have a stream that sued a developer in Florida. The second one was wild rice, which is culturally important for the Ojibwe, the Chippewa tribe in the state of Minnesota in the U.S. You have wild rice as a plaintiff. In the third one, you have salmon, the fish species itself as a plaintiff. And these 3 were brought to challenge or stop different kinds of development. The first one was a housing commercial development. The second one was a tar sands oil pipeline that threatened wild rice in the state of Minnesota. And the third one was a case against the city of Seattle because the city of Seattle uses hydroelectric dams that block salmon from being able to spawn upstream. And so 2 of these were unsuccessful. The last one resulted in a settlement with the city of Seattle, which forced fish passage to be included around those hydroelectric dams. But kind of just a short example of 3 of the cases that have been brought in the U.S. around rights of nature laws. One of the important things that's rarely talked about is that these rights of nature laws can be enforced outside of the area that passes them or outside of the tribal reservation that passes them. because, of course, ecosystems don't recognize municipal boundaries. So when we draw lines around counties or districts or boroughs, those don't necessarily align with ecosystem boundaries or bioregions. And so if a river is accorded rights within a city, then whatever happens upstream from that river that's protected within the city can be the subject of a lawsuit to try to stop what's happening upstream from the reservation or municipality, because it violates the rights of nature when that river or waterway actually enters the area that has passed a rights of nature laws. And so in the U.S., we have the highest court in the land, the U.S. Supreme Court, United States Supreme Court, which has held that tribal governments especially can enforce their rights of nature laws outside of tribal boundaries. So if there's activities of a non-tribal actor like a state or a corporation that's affecting something on the reservation, that the tribes have the power to actually bring a lawsuit against that using the rights of nature laws. So to finish up, I wanted to talk about some very new emerging things that are happening with rights of nature in the U.S. and a couple other countries. They include rights of nature easements and something called land that owns itself, which is a brand new cutting edge application of rights of nature. There are new models of protecting land. And generally, we use these when we're operating in an area that won't pass a rights of nature law, that politically it's impossible to get one passed. And so this means working with landowners. We've created a process whereby landowners can recognize rights of nature on their property through changing their deed and their title. So instead of passing a rights of nature law, we actually take the rights of nature and embed it in these easements. And then the second project, the land that owns itself, means putting together a legal entity which is essentially owned by the ecosystems themselves on a parcel of land, and then transferring the deed itself to that entity so that the land owns itself, the mountain owns itself, giving nature agency through this process. So with the easements, there's no need to get too complicated about this, but property owners have the ability to take their deeds, their title, their ownership, evidence of ownership, and actually amend them with rights of nature language so that they as a property owner can place rights of nature into that deed or title and create rights of nature, enforceable rights of nature on that parcel of land. We've now created those in 4 U.S. states. It's kind of, again, the cutting edge of moving rights of nature stuff forward when you're not in a place that will pass a binding law. And perhaps the edge of the universe here, cutting edge of the cutting edge, is the land that owns itself, which means eliminating private ownership altogether. So for these projects, we take the climate, water, plant, animal ecosystems of a specific land parcel. We create a legal entity which legally is comprised of those ecosystems as owners. And then that particular legal entity then assumes title. So the deed transfers to those ecosystems, thus completing this land that owns itself concept of nature, not just having rights, but having complete agency. So removing private land ownership altogether, creating an entity that can legally own the land, but that entity itself is controlled entirely by the ecosystems on the land. The first pilot project was completed about 6 months ago. It's a 30-acre mountain in the state of Colorado. It was given to us to transform into this land that owns itself. It's the first mountain that owns itself in the U.S. Under a Western system of law. And it has an indigenous guardianship council that's been created to help manage the land. So again, deed is held by the ecosystem. So when you look up the land ownership record, you'll see that the mountain itself actually holds its own title. So again, eliminating human ownership in the interest of creating agency for nature, kind of a beyond rights of nature project, but we think it's the future for rights of nature work to combine it with this land that owns itself concept. And anybody that wants more information on this work, our webpage is there, centerforenvironmentalrights.org. We have trainings as well as we maintain a quarterly rights of nature timeline about all rights of nature developments from 2006 through 2025. So if anybody wants more information, that's the place to go.
여러분, 다양한 사례를 통해 자연의 권리에 대한 상상을 조금 더 구체적으로 해볼 수 있었던 시간이었던 것 같습니다. 이번 강연은 시차로 인해 녹화로 진행되었는데요. 강연 녹화 당시 활동가들이 질문을 좀 나눠봤습니다. 함께 들어보실 텐데요. 첫 번째 질문부터 확인해 보시죠. 미국 내 자연의 권리 운동은 어떤 식으로 전개되고 있나요? 부족과 연대하여 활동하는지, 지역 내 개발에 반대하여 자연물을 원고로 세워 대응하는지 자세한 방식이 궁금합니다.
So we have some questions that have been submitted that we wanted to answer. One of the questions that was submitted deals with the rights of nature movement as it's developed in the U.S. What's the way that it's been developing? Is it with tribal nations, local community ordinances, or bringing cases? I think it's important to recognize that the most aggressive advocates right now for rights of nature in the U.S. are tribal governments, indigenous communities who have been passing them at a faster clip and also enforcing them more than others. But it's also important to recognize that whenever we bring a case, it's always an enforcement case of a written law. And so, if we were working in South Korea, for example, that we would be working at probably the local governmental level, that local governments, county governments, districts have power to pass environmental laws of some sort within South Korea, but that the lawsuits themselves are built on top of those written laws. So it's a way of actually creating the legal platform that you need through the written laws to actually then do the litigation on top of those.
네, 이어서 두 번째 질문입니다. 화면 띄워주시죠. 부족들의 자연의 권리 결의안 채택으로 미국 내에서 다양한 자연의 권리 활동이 활발히 진행되고 있는 것으로 보입니다. 개발 주체와 갈등은 발생하지 않나요?
So another question that we were asked is that since several tribes have adopted rights of nature resolutions, have there been significant conflicts between development interests or corporate interests and governmental entities? And the answer to that question is yes, there has. But under existing U.S. law, those confrontations always result in a victory for the property owner. With rights of nature laws, you've thrown a wrench in the process to actually make it look a lot different. And one of those initiatives, the three enforcement cases in the U.S. were all brought against development interests. The case in Florida was brought against a housing and commercial developer. The case in Minnesota was brought against a state government that was trying to permit a big fossil fuel pipeline coming down through the central part of the United States. And of course, the Sauk-Suiattle salmon case was brought against the hydroelectric power dams. And what's interesting about these cases is that when you insert rights of nature into this kind of legal framework, that you're changing the way that the law is applied. Doesn't mean you're automatically going to win, but it means that in the past, the automatic winner was the property owner, which is protected in the U.S., at least through our constitutional framework. Now it's a slightly different inquiry because you've put right against right. It's no longer regulation against right or something subordinate to the property owner against the property owner. You've now leveled the playing field or the odds. So you're dealing with rights of nature versus property rights, and you're on an even keel. This work is, from an organizing standpoint, is about trying to change the dynamic because we've been losing for the last 20 years from an environmental standpoint to actually putting it into a framework whereby we have a chance of actually winning something. And the rights of nature are a big piece of that because it changes the dynamic about how courts look at it. Also, when you put it into written law, it gives you that platform to work off of.
네, 우리나라의 사례와도 좀 겹쳐 보이는 것도 있고 또 비교가 되는 것들이 있었던 답변인 것 같습니다. 네, 이제 마지막 질문입니다. 화면 띄워주시죠. 한국은 자연 친화적 철학을 가진 지역사회 또는 부족이 없습니다. 전국에서 난개발이 진행되고 지역 주민들은 찬성과 반대로 나뉘어 갈등이 고조됩니다. 그럼에도 제주도에서 첫 생태법인으로 남방 큰 돌고래를 지정하려는 과정이 진행 중인데요. 후견인 선정 과정 및 바다에서 생계를 이어나가는 이해관계자들과의 갈등이 예상됩니다. 생태법인을 먼저 설립한 국가로서 이제 논의를 시작한 한국에 조언을 주신다면 어떤 것이 있을까요?
And then the final question dealt with the Indo-Pacific bottlenose dolphin, the efforts to recognize personhood, and the question about what advice might we offer as folks begin or continue doing this work. And it's tough because country to country is so different. And so it takes a while to begin to understand the written law and also how you can act. But I think Article 35 of South Korean law dealing with local government powers. Sometimes it's difficult to envision a written law moving at the national level. It's taken a long time to do that in different places. I think the more flexible place to operate is probably within the local governments, whether that's your tier 1 or tier 2, the lower and the higher. But finding local governments that might be willing to implement and adopt rights of nature laws. And in fact, for the dolphin, one thing we've done in the past, whether it's been in Newfoundland and Canada or other places, finding local governments that have some kind of jurisdiction over ocean environments. In other words, ones that are on the coast, where you can make a claim to passing a written law to protect ocean animals or ocean ecosystems. And the first ocean rights law really emerged in Newfoundland that we drafted in Canada a couple years ago. But finding a way to kind of, we use the term bootstrap jurisdiction around written laws, and then trying to find a place that is amenable to passing those written laws. I think litigation by itself is difficult to do unless you have that platform of a written law underneath it, which actually defines how the litigation will go forward. And so I think that's the only advice we have. But again, it's tough to give advice when you're in a different country because we don't know the politics or the culture or even the written legal system there. But I think to crack that nut, I think I would attempt to go through the local government framework and pass a rights of nature law within one of those local governments. Thank you, everybody, for your time today.
네, 토마스 린제이님의 이야기 어떠셨나요? 누군가는 자연을 살아있는 친족으로 느끼고 누군가는 죽어있는 자원으로 느낀다는 점이 참 인상 깊고 우리의 자연과는 어떠한가 되돌아보는 시간이었던 것 같습니다. 첫 번째 기조 강연으로 2025 그린컨퍼런스의 문을 뜻깊게 열어주신 토마스 린제이 변호사님께서 들리도록 우리 화면 밖으로 미국까지 들리도록 큰 박수 부탁드립니다.